Okay, Ms. Smith, you had an announcement. Was it concerning the Linzer case?
It was, Your Honor.
Okay,
The state sent in a no cross order on Saturday, I believe, but it's
Yep.
no cross to re-indict based on the discovery that the state received from the defense on Friday.
what did you receive? Was it the bank records they were trying to get or something else?
Yes, we received bank records and all the screenshots of Mr. Windsor's bank account. I also had a couple of conversations with the defense attorney regarding what his client stated as far as what he gave to the victim and what he didn't.
Okay, so I've already signed that. It'll be e-filed to this morning, the null pros. Mr. Barber called saying, hey, I'm going to be a little late. I'm not sure what's going on. And I told Ms. Nelson that he could be excused and that he could tell Mr. Linzer he didn't need to show up because of the email you sent on Saturday. Mr. Barber's concern was, well, wait, if she's re-indicted, don't we need to be here? Well, no, you'd get to be arraigned on the new indictment and all that. And so we explained to him that that's basically on pause. I guess you'd have to green sheet it because technically there's no open case here. And so Mr. Linzer's new case, should you re-indict or accuse, would hit the wheel. It's all right with me, but it's fine if it comes back here because you know about it and we can keep it here. But Mr. Barber won't be here this morning. So if you needed to talk to him, you just need to reach out.
Okay, and I spoke to him over the weekend too, so I think we're on the same page when it comes to that.
Good. The new indictment, so this would be the third version. The second version added account. Does the third version remove account or does it change the?
The third version will remove the theft by taking and add an account.
Oh, okay. The plot thickens. Well, I will leave that to you, and whenever it gets charged, you'll just need to work with Ms. Nelson to have it come back to this division.
Okay, yes, I will.
Okay. You bet. Anything else?
Nothing further.
Okay. Are you going to stay in case Ms. Willingham needs help with jury selection?
I'm still around.
Okay. All right. Ms. Willingham, is there anything you want to talk about before we bring Mr. Johnson out to cover your motion?
I don't think there's anything else that I would need to cover before he comes up.
Okay. Ms. Wood, anything before we bring Mr. Johnson out?
Okay.
Does he know about the state's motion?
Yeah, I think so.
Okay. She's not in the hospital. Well, he's been locked up, so she's not in the hospital because of something that happened between the two of them.
Not anything physical. Prior to us confirming she was in the hospital, the state was actually going to be presenting the court with a motion for forfeiture by wrongdoing. So I have a theory of why she's in the hospital.
Okay.
But there's nothing physical that occurred.
Okay. And I know you've got jail calls now too, so the plot has thickened. Ms. Wood.
I'm curious to know how my client has anything to do with the victim's COPD, but I'm listening.
It would more so just be that based on the jail calls, it appears that maybe she went to the hospital to do a survey.
Okay.
And that gets her just shy of having to be here today.
Okay. Of course, she doesn't need to be here today because we're just picking a jury.
That is correct.
But let's bring Mr. Johnson out.
Yes.
Let's bring him out. Mr. Cato, thank you for being here on time.
I was just 8:30.
I believe it. I'm not doubting you. I was saying thank you for being here. It was crazy out there. So if you had been a few minutes late, which you weren't, I was going to get it because the traffic is strange right now. Deputy Gordon, you can process Mr. Cato whenever you want, however you want, and I'll get the thing signed. Okay. Sure.
I'm so sorry. Just realized.
You're good. Yeah. No, it's fine. For that. Yeah. Okay. Well, yeah.
See. Okay, awesome, Jamie.
Ms. Wood, did you represent Mr. Cato?
Yes.
Great. You didn't make it into the final disposition. Need to get you in there. Well, perfect. Thank you. All right. Are you ready? Ms. Rivers, let's get on the record. This is 25 SC 007-554, State versus Melvin Johnson. It is Monday, the 16th of March. We'd be done with the World Cup by then. Not quite. 16th of March, and we are here to start the jury trial for Mr. Johnson. Mr. Johnson is here. Good morning, sir. With his two lawyers, Ms. Wood and Ms. Rios. We have Ms. Willingham here for the state. And Ms. Willingham, there's something you want to get on the record before we start working through the logistics of trial.
Yes, Judge. So initially, the state intended today to actually do a motion for forfeiture by wrongdoing, based on several jail calls. However, we have, one of those calls indicated that the victim may be in the hospital. So we were going to just acknowledge to the court that there was a possibility.
Talking about Ms. Mitchell.
Yes, Your Honor.
Okay.
Since that time, we had actually been able to confirm that she actually is in the hospital. And with that, we still believe there's a forfeiture by wrongdoing issue here. However, we do believe that we have to be completely open with the court in that the victim is in the hospital, so we don't expect her to appear today. The state's concern with us moving forward in jury selection today is that if she does not appear tomorrow and we have to move forward by forfeiture by wrongdoing, we also have a witness who would have issues with the remainder of the week. The state did not expect this case to take very long. We thought our officer would have been able to testify tomorrow with no issues. But contingent upon how the court rules on that forfeiture by wrongdoing, if you deem that it's not and that we need to have the witness here, we couldn't do it the rest of the week because our officer would not actually be available because he has military leave.
Got it. So who's
Asking for next week.
okay? Our officer who is available only tomorrow, the officer is available?
Yes, McCray, Officer McCray.
Okay, and that's, I have here Investigator Shelton McCray.
Yes.
Same person?
Same person.
Okay, and his role in the case is?
As to the third count of the indictment, he is actually the lead. He actually is the person who was able to secure the identification of the defendant from the victim. And that is actually how they were able to also confirm the defendant's identity in the aggravated assault, which is the first count.
Sure, so he was known as Blue, flowing out of the April part of the investigation.
Yeah, well, out of the April part of the investigation, they really just had Melvin Johnson. They did not have
His actual name.
correct.
Okay.
But it is a common name. They did not have any other details identifying him, and the victim had only named him. They were not able to get back in touch with her to confirm anything beyond that until they were able to speak, until Investigator McCray actually was able to track her down and speak with her.
Okay, so his role is important in connecting the name Melvin Johnson to the Melvin Johnson who's sitting in court today.
Correct.
Okay, but he could testify tomorrow.
He could.
All right, let's pivot then back to Ms. Mitchell. Do you know which hospital, you don't need to tell me, but do you know which hospital she's in?
We know which hospital she's in, Judge. We know which hospital room, and we talked to her on the phone. There is a expectation that she could be out today.
Do we need to do a material witness warrant,
So,
or you'd prefer not to?
well, so technically, we really couldn't, because it's a domestic violence case and based on I know we're on YouTube, so,
Well, and I'm not asking you to reveal something you're not supposed to reveal. I'm not familiar with there being law, maybe it's policy, but law that you can't get a material witness warrant if you have a material witness who happens to be the victim, but is material to your case, who is saying, I'm not going to show up.
it's policy to some extent, but it's policy not necessarily our office policy. It is directly related to how I may be standing in this courtroom. So, that is not something we would be seeking, but we do. But again, I don't think it is a issue where we would need to do a material witness warrant, I do believe the state has a strong argument for forfeiture by wrongdoing in this case. And that was the route that the state fully intended to go on. Even after we learned that she might be in the hospital, it was still our intent to make that argument today.
Okay.
But now that we've confirmed that she is there, it's hard to completely say that she won't show up, because technically she also can't, because she's sitting in the hospital.
Right now she is, but it sounds like your understanding, and it's secondhand, but your understanding is that whatever brought her to the hospital, the treatment or the evaluation, and that should stay private, would be complete today.
That is my understanding from what was said on a jail call.
Okay.
I just know that right now she's in the hospital.
Okay.
But from what we heard on the jail call, it sounds like she may be getting out today.
Okay.
My communication with her yesterday, it did not sound like she thought she would be getting out today.
Okay.
So
What did she tell you she might be out tomorrow, or that it was a long-term hospitalization?
she said she was not sure what day she would be released.
Okay.
And that was where she left it, was she was not sure what day she would be released. She knew she wasn't gonna be released, she said today. So
Okay.
that left us kind of in limbo. Again, the outside of that, the state is completely ready and would ask to still be able at latest to go on next Monday. I know this is a speedy, we would still be ready first thing Monday morning. And if she did not appear at that point, we would just be asking to move forward from the forfeiture by wrongdoing. And I believe we would be able to be successful in that.
Okay. And do you have any reason to think that Ms. Mitchell would be any more available next Monday?
And Judge, I guess that's the hard part, is she has expressed to us that she would come. So unfortunately, until she doesn't, I can't say that what has happened on the jail calls has been successful to keep her from coming.
Okay.
I guess that's the awkward spot I find myself in at this moment.
That we all find ourselves in, because Ms. Mitchell's a necessary part of whatever's going to happen with this case, and the jury ought to hear from her about what she has to say. So no one from your office has spoken with her today to say, what are you hearing? Oh, I'm getting out at noon. I'm getting out at 3.
No, we have not spoken with her this morning, Judge.
Okay. Is she reachable? Yes.
We can give her a call. I was gonna say, we have a number for, we have a number that we should be able to reach her at, so we can give her a call and see.
Okay. Other than that, when does McRae get back from military, whatever? Okay. So next week would work for
Yes.
McRae.
Yes,
And tomorrow works for McRae.
and tomorrow works.
Okay.
As mentioned, I guess my biggest concern is just swearing in a jury, and if the court decides not to move forward on a forfeiture by wrongdoing if she doesn't show up, and instead grant the continuance because she's still in the hospital.
We wouldn't swear the jury in before we work that out.
Okay, that's my biggest concern here.
Okay, got it. Ms. Wood, I'd like to hear from you on this scheduling issue. Not the forfeiture part, we're not there yet, so,
I'm happy to be heard on that when it's appropriate.
okay,
Judge.
it's not.
Thank you. We are ready to go forward today. My preference is that we pick a jury today. I think this should be a very short case, so I think if we can have witnesses here tomorrow, that would be my preference, so.
Okay. Because it's short, that gives us some flexibility this week. It might not be the ideal sequencing for the state in terms of the order in which they present witnesses, but if we learned later today that Ms. Mitchell will be available Wednesday morning, but not tomorrow. Certainly could take testimony from Investigator McCrae and any other witnesses you wanted to put up. And I don't mind explaining to the jurors that look, scheduling is complicated. Tomorrow is only going to be a half day, or however many witnesses you choose to put up. And you might not want to put up many others before Ms. Mitchell testifies. Now, if you were planning on putting up 0 witnesses before she testified, but she can't be here till Wednesday, that's the McCrae issue presents itself.
And Judge, is that we would, based on the fact that we're even talking about a potential forfeiture by wrongdoing, I would want Ms. Mitchell to testify first. That is part of my concern.
Okay.
So,
Why don't we do this? I would like to get the jury today because who knows what's going to happen between now and next Monday. I would like to hear a little bit while we're waiting on the jurors about the phone calls because I may need to put some measures in place where Mr. Johnson's done using the phone other than to talk to his lawyers between now and the close of the trial. But my thought is that we qualify, it's not really the right verb, but we engage the jurors on, hey, we're picking a jury today. Ideally, you'll all come here tomorrow, but it's possible that you all come here next Monday. So we pick the jury today and we'll make sure, hey, who's got a conflict over the next 2 weeks? And understand someone says, I'm going to France next Monday. That's not a good juror for us. Not because this case would last that long, but it's conceivable that we wouldn't bring them in to swear them in and start the presentation of evidence until next Monday. They're not going to forget anything about the case between being selected today and next Monday because they haven't heard anything about the case. But we've got everyone here. There is the real possibility that Ms. Mitchell could be here tomorrow morning and be your first witness. And then we've worked through that. I would ask you to have your team engage with her on that. If I can assist in any way in ensuring her appearance, I'll get involved with that, but you're going to make the decision as to whether you want any enforcement power to getting Ms. Mitchell here.
yes, Judge.
Okay? Anything else about scheduling from the state?
No, I think that should cover us.
Okay. Ms. Wood?
I'm good, Judge.
Okay, you're just standing?
I was gonna tell you something about the forfeiture by wrongdoing, but I'll continue to wait.
You'll hold on that. Okay. Ms. Nelson, can you order up the jurors, please? It being a Monday, there's a long line for jurors, so we might as well get in the queue to see if we can get anyone here. All right, let's take care of a few other things. Ms. Willingham, I didn't bring the trial calendar out. Good morning, Colonel. It's always nice how he stands up when you walk in, or when I walk in, he's like, I'd like to get the offer on the record again, so that Mr. Johnson can say, well, I've changed my mind, or no, thank you. We went through this just last Thursday, but here we are. There may be no offer now, but.
And Judge, based on communications I had with Ms. Woods this morning, the state would put the most recent offer on the record, which is actually just a little bit better.
Okay.
Than what we left with.
So if Mr. Johnson were entering a plea today, the state's recommendation would be what?
Would be 15 years to serve 5 years. And we would obviously be withdrawing the recidivist notice.
Okay. If Mr. Johnson goes to trial and is found guilty on one or more of the counts, you intend to effectuate the recidivism notice?
Yes.
Okay, and that's an A and C notice,
Yes.
even though in the indictment, he's not charged with possession of a firearm by a convicted felon?
That is correct.
Okay. All right, Mr. Johnson. I got to get it on the record before, and you actually have to say words and not just sullenly shake your head, okay? The state's offer is now, it's lower, and it also is parole eligible. It would be a term of 5 years in custody for which you get the credit for the time you've already been in. It's a parolable 5 years to be followed by 10 years on probation. So 15 to serve 5 as a non-recidivist. Do you feel like you understand the recommendation?
Yes, I understand.
Okay, and is that something you want to pursue? Okay, I respect that. I'm going to ask Deputy Gordon to circulate the indictment so the not guilty plea can be recorded on that. Ms. Wood, are you comfortable moving forward with it? It's actually a copy of the indictment. Thanks. And Mr. Johnson, just so if trial goes forward and ends up not a good result for you, I want to make sure, I want to be explicit about it. The state apparently has collected at least 3 felony convictions of yours, copies of which if you're found guilty, they would tender those to me. And if they're valid certified copies, and they usually are, then you would be sentenced as a recidivist, meaning whatever prison time I gave you would be non-parolable. So if I followed, the same recommendation, 15 to do 5, just would be 5 to the door every single day. You get credit for the time you've been in, but you'd still have 4+ years ahead of you. Do you understand what would change if you're found guilty after trial? Okay, great. Ms. Willingham, if we start tomorrow morning with openings and are able to basically fill each day because witnesses are available, how long do you think your presentation would be?
Judge, I don't expect us to go past Wednesday morning. I do have a officer that I potentially would need to take out order to take tomorrow, as he has some medical stuff on Wednesday. Not asking for accommodations for that. But I think we should go past Wednesday morning.
Okay, well, it's a short enough trial that you should seek the accommodations that make sense. You know, if we, again, making it up, if we're able to start tomorrow morning and you say, could we stop at 4 because I can't get someone till tomorrow morning, we can stop at 4. We wouldn't be pushing the jurors past any deadline.
Well, so part of the thing that we found out was so we were notified Friday afternoon that one of our officers, tomorrow has training, but we were like, oh, that's fine, we'll take it Wednesday. And then late Fridays, when we found out, well, Wednesday, they have a doctor's appointment.
So then they need to miss training.
That is what I said. So,
Okay.
We can make it work. We would just take him closer to the end of the day, Tuesday, to allow him to get as much of his training as possible.
Okay.
But that's the only other. So I still think, with that, I still think that we would be able to be finished by Wednesday morning.
Okay. Your witness list has 18 names on it. Are there any that you know now we could remove so we're not qualifying jurors for witnesses you know you're not going to use?
Sorry. So one of the 911 custodians, I think we're only using Ms. Harrison. I think there's still a pending motion in regards to Ms. James that we would still need to take up.
Right. So we're not using Ms. Nelson?
Correct.
Okay. And is it Ohio or Ohio?
Ohio.
Okay. And yes, we'll talk about Rosa James.
And actually contingent upon the forfeiture, I may end up having one additional witness.
Okay. But it's,
Everybody else, it looks like the same.
okay, great.
Still don't think it's gonna go past Tuesday.
All right.
Short witnesses.
Ms. Wood, as you think about your cross-examination of witnesses and any presentation on your side, you think it's a 2-day, not including jury selection, a 2-day trial?
At the moment.
Okay. Do you, Ms. Wood, have any witnesses other than your client who are not on this witness list that we need to,
The state would like to go ahead and proceed forward with the forfeiture by wrongful motion.
Okay.
It was discharged yesterday at 5:57 p.m.
Okay, but let's first answer my question about other witnesses.
No.
Okay, so our universe is the state's witness list plus Mr. Johnson.
Yes.
Okay, great. So what you said, Ms. Willingham, is that Ms. Mitchell actually is not in the hospital.
She was discharged yesterday at 5:57 p.m., Judge, and I actually spoke with her yesterday. Sorry, I want to be correct in the time. I spoke with her yesterday at 10:12 a.m. And during our conversation, she stated that she would not be released yesterday, that the earliest possibility of her being released would be today.
Yep.
And that she would notify me as soon as she was released. She
Okay,
spoke to Investigator Scully yesterday as well, that she would notify him upon her release. She understood that she needed to be here today. That was made clear by myself as well as Investigator Scully, and
okay,
she's not present. And although we know today was only jury selection, we asked her to be present today.
Sure,
specifically
just
because we
to
expected.
get her comfortable. Okay. So the two issues we need to work through while we wait on jurors would be your forfeiture question, and then Ms. Wood filed a motion to eliminate in connection with Ms. James. Let's start with the forfeiture question, and then we can.
I do have a drafted motion that I can send to all parties if you want that, or we can just make arguments. It's fine either way.
Well, let's start with argument since we're all here, and we should start talking about it.
Judge, so the defendant in this case was placed in custody on October 29th of 2025, and the state formally subpoenaed Ms. Pamela Mitchell on March 3rd, 2026. Between that time, on March 3rd, 2026, I believe around 1:20 p.m. Between that.
As in someone handed a subpoena to her?
Yes, Judge. She was subpoenaed in person by Investigator Scully on March 3rd. During that time, actually, when he subpoenaed her, he had to take her around the corner because she was afraid of the people who were in the home that also know the defendant.
Was this the Joseph E. the 252 Joseph E. Lowry address where the September and October allegations arise?
That is correct.
Okay.
So they went around the corner during that time. I was also able to speak with her where she also expressed her fear of having to move forward. She was very adamant that she does believe that she wants to move forward with the case, but she was very afraid of having to come and testify. She made that clear to myself as well as Investigator Scully.
On March 3rd, when she was being
March 3rd.
subpoenaed. Okay.
Yes. Subsequent to that, from March 3rd to March 26th, to March 12th, there were at least 39 calls to the victim directly.
Why do you pick March 12th? That's just the last time you got.
At the time of my drafting of the motion, that was the last time that I had counted. I have, of course, since then listened to several other calls. And in that, I've also realized that the defendant has spoken with her on a few other numbers that are not included in that 39 calls. But during some of those calls, just to pinpoint, there was a call on, and even going back, before the March 3rd date, there was a call on March 1st. In the last few seconds of the call.
Before you dive into the contents of any calls, all these calls have been provided to Ms. Wood?
All the calls that I will address, yes, have been turned over to Ms. Wood.
Okay, she's shaking her head. And I want to note, first of all, if you got them yesterday, yes, physically you have them, but if it's hours and hours, maybe you haven't had a chance to listen to all of them.
So I need for someone to clarify, there are a ton of jail calls that were turned over to me. I did listen to the ones that I have an axe on. I need a specification because a lot of the ones they dumped on me were literally just, this call cannot be completed as dialed. I'm assuming for the state to show that they're trying to reach out to someone, there needs to be proof, because under the Georgia law, there has to be proof for ongoing for this forfeiture by wrongdoing to succeed.
Okay,
That is correct. I can actually tell you exact calls, and I can send you the specific ones when we sent them over. At the time, my legal assistant sent them prior to me having the opportunity to go through all of them. I'm gonna pinpoint 4 specific calls.
okay. The first was the March 1 call.
Yes, March 1st, 2026. And if you look at I'll copy the numbers and send them over, but.
And when you say numbers, the phone number or the timestamp?
No, it is a timestamp with a phone number, but the way that they are titled, it's a very lengthy, title of them. So I have also pulled them into a separate folder, and I can send those to Ms. Wood, so she will have the 4 calls I'm specifically referring to.
Okay. And you feel comfortable that those 4 calls were part of the overall universe you shared with Ms. Wood?
I opened the folder that was sent to Ms. Wood specifically to make sure that I only pulled calls from that.
Okay,
folder.
great. Okay.
So the March 1st, 2026 calls, in the last few seconds of the call, the defendant says to the victim, be on point for them people. I want to talk in code, be on point for them people. And then there is a subsequent call on March 3rd, 2026, after the victim was served, where the victim asked, why are we trying to go to trial? She says, do I need to come or not? The defendant says, no. She says, big man told her that she should come. And the defendant says again, no. He says he wants to know how we got her phone number. She then explains to him that we were given her phone number after I spoke with Ms. Woods, who was able to confirm that one of the numbers I had was a good number for the victim. He then went on to proceed how he was upset that his attorney had confirmed the number. I recognize that the defendant does not know that was just Ms. Woods doing her job. But he further goes on to tell her not to participate. If you do not show, they can't do anything. He says at the 4-minute and 30-second mark, the defendant tells the victim again not to come. Again, at the 5-minute and 45-second mark, he tells her, no, don't go. And he tells her that after she says she doesn't know if she should go or not. He tells her specifically, don't listen to big man, F him. Do what we say we was gonna do. And he says that at the 9-minute mark of that same talk. And then he says, we from the hood, I know y'all listening, F that. He then further says, I don't appreciate my lawyer for giving the DA your number. They ain't got you, they ain't got nothing. Then going into March 6th, them folks ain't called you back no more.
So now a different call.
This is a different call. She says, no, and I'm not gonna answer. He says, that's right, baby. And during all of these calls, Your Honor, he is also acknowledging to her that he's going to send her money. He acknowledges that he's gonna make sure that she has a place to stay. And then going into March 9th, that is a different day. Them people offered 15 and served 8. That's why I'm taking it to trial. Hell no, I ain't taking that. I gotta wait it out. If nobody comes, they gotta throw it out. And That is the last call that I stopped at taking notes at, Judge, but there are several calls that occurred after that as well. Again, that's how we learned that the victim was in the hospital. And although I will.
Meaning through a call between Ms. Mitchell and Mr. Johnson, you learned?
Correct. And Your Honor, in full candor, those calls Ms. Wood would not have yet, but I have been communicating with Ms. Wood throughout this whole process, letting her know that I was getting this information. And I mentioned to her that in one of the calls, the victim and the defendant are speaking, and I'm sorry, let me backtrack. They speak very briefly, but then the defendant makes a call to an unknown party. And when he calls that unknown party, he tells that person to call the victim. And that person says, because she can't come. Do she understand what you facing? She can't come. And he subsequently.
That's not what Mr. Johnson says. The unknown person says this.
Correct. So then Mr. Johnson tells that person, I know, man, call her. So they then call Ms. Mitchell. And Ms. Mitchell has COPD, so her voice is very recognizable. It was very clear that this was Ms. Mitchell that they were calling, and Ms. Mitchell then says that she's not going to come. He tells her that he's going to send her that money, but he asked her, have you gotten your ID yet so I can send you that money? And he tells her how she was going to get it. Then is when they learn that Ms. Mitchell defendant then realized Ms. Mitchell says she's in the hospital. And she says, well, I'll be here till Monday. And again, Judge, the state would have their argument as to why we believe she's there till Monday, especially considering during that call, she also acknowledges that it's not necessarily for the treatment of her COPD, but more so for a study, which conveniently would stop her from having to appear. But Ms. Mitchell has made it very clear to us in several instances that she was afraid, and my investigator would be able to speak to her demeanor during his actual interactions with her. I can only speak to her demeanor over the phone, but she did sound very scared, so much so that he did not actually drop her off at the home. He had to go around the corner to make sure that he was not seen dropping her back off at the home because she was afraid. So, Judge, in every conversation, she has been helpful in what happened. But she has always expressed a fear. And at this point, her finances that is being funded by the defendant where she stays. There are people in that home who are communicating directly with the defendant. She is being contacted by people outside of custody. And I will not speak as to who those people are specifically because I do not necessarily know. I just know from what I am hearing on the phone. Judge, and went so far as to, there was another potential witness that the state would have potentially called that he also made sure that his family communicated with. And she is heard on the call saying that I will tear up, or I tore up the card. I'm not gonna go, because he also is emphasizing to his family that that person also does not need to appear because we are trying to bury him.
Okay. And tell me what relief you are seeking other than a continuance.
Judge, the state would be seeking to get in all of Ms. Mitchell's statements made to law enforcement regarding this case, based on the fact that her appearance has been stopped because of the defendant.
Are those statements that the defense has?
Yes.
And are they like body cam recordings or an interview in a precinct interview room? Or is it more a police report where Officer Jones says, Ms. Mitchell told me she was shot in the arm?
No, Judge, all of them, I believe, are captured on body camera. I think there's one that I referenced in regards to the identification and confirmation via a text message. In all candor, I do not have the text message, but Officer McCray would be able to speak to, I sent this photo to the victim and she subsequently said that, yes, that is the defendant.
Okay, so it's admitting the sum and substance of what she relayed to law enforcement, it would be on multiple occasions. I guess there were some interactions in April when she was at Grady or wherever she went to get treatment for the gunshot wound, and then interactions in September and October.
Yes.
Okay. Now, what about, I don't know if Investigator Scully or someone in your office interviewed her. Would that also be something? Or just when you say law enforcement, you mean the various APD officers who interacted with her?
I would potentially call Investigator Scully, but that would be as to the conversation that I just mentioned. Because during that conversation, we talked through what happened. So she again would be Investigator Scully would be able to testify that this happened. That conversation was not recorded, but it is the conversation that I just put on the record in reference to the actual motion explaining what his interaction was with her in the car. During her time in the vehicle, she did tell us what happened at least on the April incident for the shooting.
Okay. And what would Ms. Wood have that summarizes what Ms. Mitchell told Investigator Scully?
And I could have Investigator Scully summarize, I can have him do a quick supplemental. It was a very short conversation, no more than 5 minutes, and I can provide that if Investigator Scully is needed at this.
Okay. So I don't know how I'm going to rule, and we may yet get Ms. Mitchell. I trust your team is going to work hard to try to connect with her. If you find her, she can testify right then, other than if you find her today, she can't. But if I grant your motion and Investigator Scully, you plan to call him before he testifies, whether it's his notes or a summary of his notes, needs to get to Ms. Wood so she knows, well, what's he going to bring up? And he may say, yeah, and she said she got shot in the left arm, but it was the right arm. She's just entitled to be able to process all that.
Yes, sure.
Okay. And that would be the one witness for whom there isn't already a write-up or body cam that you'd be calling.
Correct.
Okay. All right. If you could email to me and Ms. Nelson and Ms. Wood the skeleton, whatever you said you started working on a motion. It'll be helpful to have statute if there are any cases in there.
Yes, there are 2 cases, and I've also printed copies of those cases, so I would provide copies of them as well to Ms. Wood so that she can have them.
Okay. All right. Ms. Wood, I, of course, I'm going to hear from you. Deputy Gordon, I can see silhouettes out there. Are jurors already here?
Yes.
What? We normally wait days for jurors. And then on a rainy day, are they lined up? Okay, then Ms. Wood, I'd like you to start, but when Deputy Gordon comes back in, we may pause the discussion and wrap it up later today.
That's fine, Judge, and I just want to be certain that I'm responding appropriately. Is the state moving on this forfeiture by wrongdoing to get the jump balls in or to delay the speedy? I'm a little confused.
Judge,
Fair question.
And the state would not be asking to delay the speedy. If the court is granting the forfeiture by wrongdoing, the state would just want to get all the victim statements in, and not just the jail costs. It would include the jail costs as well as all of the statements I just previously mentioned that the victim made to law enforcement. But we would not be asking to, if the forfeiture by wrongdoing is granted, we don't even need to wait till next Monday. We could just proceed forward now.
Right. Okay. That was my understanding, but thank you for clarifying it. I wasn't contemplating the sanction is I can blow up the speedy. Maybe that's happened before. I don't know. I'd have to research that as well. But I wasn't thinking about that. I was thinking about how, independent of a speedy, if there's a jury and then it turns out there's a witness whose absence was created by actions of the defendant, then this is the potential remedy. I still intend to engage the jurors on their availability for Monday, Tuesday of next week, because that might be the in-between ruling here, which is, this doesn't sound great, but let's just see if we could start with openings next Monday. And if we do that, that gives the state more time to try to connect with Ms. Mitchell.
Yes, Judge. And the only thing that I wanted to say was that I think I've seen the case law that Ms. Willingham is going to reference, the case that I found with Lopez versus State, 355 Georgia Appeals 319. the state has to show the defendant engaged in wrongdoing, wrongdoing was intended to procure the declarant's unavailability, and the wrongdoing did procure the unavailability. I don't think that's been met so far, because it sounds like Ms. Mitchell is gonna come in here and testify to the jury. We'll all ask her the questions we wanna ask. But I would let the court know, I do wanna give up Ms. Billingham, because it does sound like there's at least a couple of jail calls that I have not heard yet, so I would like to listen to those before I say anything else about this.
Got it. No, it sounds like there are more recent ones that weren't in the up through March 12th disclosure. So those are easy enough, I think, to email across, whatever. And I would like to listen to at least those four. You mentioned the four that
Yes.
you had identified out of the larger universe. It sounds many of which were, no one answered, whatever it was. Sometimes tone makes a big difference too. The words don't sound particularly favorable to Mr. Johnson, but tone, and especially if they're more recent ones, like the one where this third party is then engaging Ms. Mitchell. It sounds like that was one that was so recent that Ms. Wood.
Yes, Judge.
Wouldn't
that
have
was one
it.
that I listened to on Saturday morning.
Okay.
So I will also get some assistance in getting that one downloaded. I knew that I could not directly download it, as then I would.
Right, that's why you have Jill Hollander.
Yes, so, now that I will go ahead and get that one as well.
Okay, great. So I will table the discussion. Ms. Wood, you certainly ought to get a chance to listen to some of those calls. I would like to as well. And none of this interferes with our ability to get the jury. The one thing we didn't talk about, you all have survived voir dire in here, so you know the format. Were there any questions that I did not include that the state wants in the list, or that I did include that you want out?
The only question the state wanted included that wasn't was, whether anyone had been the victim of domestic violence.
I will make that explicit. There is have you been the victim of a crime of violence? And I say whether it's reported or not, and I will say that includes domestic violence.
And I was gonna say, that's how we've handled it in the past, so I just wanted to make sure of that, and I didn't know if the court was withholding on that ruling until we dealt with whether Ms. James would be testifying, so.
Got it. No, I typically, you have the gist of the question here, but when I talk about if you've been the victim of a crime of violence, I say regardless of whether or not it was reported, this includes domestic violence. So I think that'll capture it.
I would agree.
Okay.
With that.
That's it? Okay. Ms. Wood, anything you want added or subtracted?
No, you're right.
All right. Are you trying to escape now?
Yes, Your Honor, I was gonna ask that.
You sure, you can, whenever Ms. Willingham says you can go. So Ms. Willingham,
I'm trying to get somebody down.
okay. Oh, if I don't know the person, just like email the name and I'll introduce the person. But for now, you're solo. Are they here?
Yeah.
Okay. Okay. Great.
I just sent the case law motion and the phone calls that I referenced in my argument.
That's one big care package.
It is.
Did you all get jury paperwork yet or not? Juror paperwork?
Okay. Did you have it? Yeah, okay.
So we just missing one,
What number is that? 50?
Yeah.
It's always towards the end. Okay,
Oh, she didn't, okay. Ready?
we are.
Something's going down. No. So it's side for them.
Yes. Oh, that's done.
And so, first we're gonna go down into.
We got a lot of deputies for this.
Latina people are the only ones in their right mind.
Hey, there you go. Are you a lefty?
I am.
Joey, shouldn't you be out there finding someone?
Yes, sir.
Going
Well,
to, as soon as I get someone here.
You feel all alone.
I'm just pinch hitting. I'm ready to move.
Just put that off, and then you just stay in line and follow your rules. Follow the road.